today's episode, we'll be looking at the issue concerning the emirship tussle in Kano State. Of course, we had opportunity to look at this issue robustly last year, of course, whereby the new governor reinstated the former emir of Kano, Emir Sanusi, and abolished some of the emirate councils that was created by the former governor. Of course, that was issue for the court to determine, as the deposed emir went to court to enforce his fundamental right. Of course, the Court of Appeal yesterday, in consideration of some of the cases involving that tussle, nullified the decision of the State High Court regarding the emirship tussle and directing the State High Court to reassign the case. Of course, they cited the example of breach of fundamental right of the former emir. So we'll be looking at all of this issue vis-a-vis the issue concerning fundamental right and all of the history surrounding this case, so to say. And also, we'll also be looking at the issue in Oyo State concerning the emergence of the new Alafin of Oyo. Of course, within the week, we are inundated, with the approval by the governor, Seyi Makinde, of the appointment of the new Alafin of Oyo. Of course, that also raised controversy, as the kingmakers has allegedly written, citing illegality and unconstitutionality in that appointment. So we'll be looking at this vis-a-vis the state involvement in traditional institution and the law governing appointment process of this traditional, revered traditional tools and institution. These are the topics we'll be looking at today's episode. We'll go on a very short, and when we return, we'll introduce our guest who's already seated in the studio this evening. I'm Kenneth Wimo. Stay tuned. We'll be back shortly.
Governor Seyi Makinde approved the selection of Prince Hakeem Owode as the new Alafin of Oyo. Prince Owode is a Nigerian and Canadian entrepreneur, philanthropist and president of 100279 Manitoba Limited, a real estate investment and financial services business in Manitoba, Canada. Born 48 years ago to a prominent royal family of Owode Agunloye in Oyo State, Prince Hakeem Owode, one of the surviving children of Parazaki Biyosi Owode, the descendant of Aremo Aderomu Inyoda Owode, Agore Compound, Oyo Town in Oyo State, Nigeria. Prince Owode completed the secondary school education at Baptist High School, Shaki, Oyo State, Nigeria in one of the surviving children of Parazaki Biyosi Owode, the descendant of Aremo Aderomu Inyoda Owode, Agore Compound, Oyo Town in Oyo State, Nigeria. Prince Owode completed the secondary school education at Baptist High School, Shaki, Oyo State, Nigeria in 1992. His father worked for Oyo North Agricultural Development Program, helping Okeogun community in boosting agricultural productivity. Prince Hakeem Owode began his engineering studies by completing his national diploma and higher national diploma in mechanical engineering from the Federal Polytechnic Ilaro, Ogun State, 1994 to 1997, and the Polytechnic Ibadan, 1999 to 2001, Oyo State, Nigeria, respectively. He did his NYSC with Nigeria Gas Company as mechanical intern planner in 2002. After the completion of his NYSC, he worked with Oceanic Bank International PLC in Warri as a teller from 2003 to 2004. Prince Hakeem Owode furthered his education in the United Kingdom, where he attended University of Sunderland 2008 and Northumbria University 2012, from where he earned Bachelor of Science and Master Science degree in Mechanical Engineering, respectively. Prince Hakeem Owode became certified in project management in June 2015. Kingmakers in Oyo have described the appointment of Prince Abimbola Owode as the new Alafin by Governor Seyi Makinde as illegal and unlawful. 5 kingmakers from the town declared the appointment null and void because they did not recommend such a name to the state government, insisting that the only person they recommended as the next Alaafin is Lukman Badegeshin. They noted that they were surprised by the announcement by the government. It claimed that the selection was made after wide consultation and divinations. Under the registered Alaafin of Oyo Chieftaincy Declaration of 1967, it is only the Basharun of Oyo, the head of the Oyomisian Kingmakers, that can summon a meeting of the Kingmakers for the purpose of selecting a candidate to fill the vacant stool of the Alaafin of Oyo. In this instance, the Basharun did not summon any such meeting, nor was there any meeting convened in the Alaafin's palace discussed of the months where the said Prince Abimbola Akeem-Uwade was elected or appointed as the new Alaafin.
Welcome back. If you are just joining us, you're on to your favorite program, Democracy on the Rule of Law. With me on the show this evening is Barrister Obiora Ume, a respected legal practitioner, practicing here in Lagos. Very soon, welcome you to the show this evening.
Thank you very much, and good evening to our esteemed viewers.
All right. Of course, we'll say in the commentary regarding the controversy, regarding the appointment of the Alaafin of Oyo by the Oyo State Governor Seyi Makinde. Of course, there's been an alleged revolt by some of the kingmakers for citing an instance that they did not recommend such appointment, and that Basharun is only constituted authority to summon a meeting of the kingmakers with such appointment. So what do you have to say concerning all of those issues? Because we have some of those issues in Kano too concerning traditional institutions.
Yes.
And one will begin to wonder how come traditional institution and mainstream politics.
I believe that once again it is necessary to state clearly, loudly and categorically that traditional institutions must be insulated from politics, because these are the institutions that have survived over the years. Traditional institutions are institutions that over time have governed the customs of the people. And in Oyo State, we know that the 1967 Chieftaincy Declaration, duly registered, made provision for the procedures for the appointment or selection of the Alaafin of Oyo. And by virtue of the provisions of that Chieftaincy Declaration of 1967, it is only the Basharun, the head of the Kingmakers, who is to summon a meeting of the Kingmakers. And when the Kingmakers meet, they will deliberate and finally recommend someone to the governor for appointment. That has been the procedure over the years. But this time around, unlike what the declaration provided for, it was the governor, Seyi Makinde, who has, upon consultations, wide consultations, has declared and appointed Uwade as the new Alaafin of Oyo. The question now is, has the governor the power to override the clear provisions of the law governing the appointment of the Alaafin of Oyo? Is the appointment a political appointment that the governor can use his powers to do? As far as I'm concerned, traditional institutions must once again be insulated from politics, since there is a registered declaration of 1967 that governs the procedure for the appointment of the Alaafin of Oyo. It is necessary to comply with that declaration, because we have seen what is playing out already, that the kingmakers have declared the appointments as illegal, as unconstitutional, as null and void, because the appropriate person that is expected to summon a meeting, that the Bashoro, never did so. And the kingmakers were not the ones that selected the new Alaafin of Oyo. Instead, there is one person that the kingmakers are more comfortable with, in tune with. So now the question is, by the provisions of the Declaration of 1967, who is the right person, who is the appropriate authority to select and recommend the Alaafin of Oyo? Is it the governor or the kingmakers? It is clear. The declaration says it is the kingmakers who are supposed to do so, which means that what the governor has done appears to have been done without the necessary authority, like the phrase "Who warantu," who authorized you. The fact that he's the governor of the state does not mean that he has the powers to override clear provisions governing traditional institutions. The persons, the kingmakers who are supposed to do that, have come out to say they never knew anything about it. And as far as the issue of the Alaafin of Oyo is concerned, they are the rightful authorities. And you see, this reminds us of what happened in Kano, where the governor decided capriciously to remove the then Emir of Kano, and the deposed Emir went to court. Of course, the matter is still subject of litigation, but we have said, I'm going to say that what is happening in the political arena is not very encouraging. We see abuses. We see people trying to exercise powers that do not have under the law. We see things that are not in clear conformity with the principles of rule of law and democracy. We have seen that politicians take certain actions that can be seen as purely motivated by selfish interests. We recently looked at what is playing out in Edo State, where the governor went ahead and sacked the local government chairman, when under our law, he does not have such powers. We condemned the act, and he went back and used the councillors to attempt to impeach, and in fact they appeared to have impeached some of the local government chairmen. Now, must the governor have his way, or is it the masses? Because democracy, as we've known it over the years, is that the majority must have their way. The minority must have their say, but the majority must have their way. And the masses have elected people as local government chairmen. Now the governor is not comfortable with them and is using all means, whether proper or improper, to make sure they are eased out.
Yeah, but what role is the government, the Oyo State government, supposed to play in the selection process of the new Alaafin of Oyo?
Now, the procedure, like we've already seen, is that the Bashoro, who is the head of the kingmakers, will summon a meeting of the kingmakers, and they will meet and deliberate, screen, and select someone who will now be recommended for the governor for appointment. It is not the governor who is to do the selection and then appoint. That is not what is supposed to be. And the Bashorah has come to say that he knew nothing about the purported appointment. The kingmakers have equally said that they never deliberated on the new Alafin of Oyo. And I had cause to look at the traditional institution in Oyo State. Is a very long-standing traditional institution that has survived over time. And I also know that the Alafin has powers, word powers, as far as the customs, the traditional institutions, and so on is concerned. But then, you still have what one can look at as checks and balances in that institution. Because in spite of his wide powers, if the Alafin tries to do something that is against the customs of the people, the tradition, the mores, then the kingmakers will now compel the Alafin to open the baskets, the calabash, rather, not but the calabash. And that is a way of limiting the enormous powers of the Alafin, which means that the kingmakers have powers to checkmate the Alafin, and that has been their tradition, which means that in spite of the powers of the Alafin, he cannot go beyond the powers that he validly possesses. Now, it is incumbent on the governor of Oyo State, Seyi Makinde, to allow the traditional institutions to remain intact. It's not good for the institutions to be discredited or undermined. It is not proper. It is not right. As far as I'm concerned, let the proper procedure for the selection of the Alafin be followed.
Okay. So how has the role of the Alafin evolved in modern governance? Obviously, we see that state governors are becoming interested in some of these traditional institutions. So how have their role evolved in modern governance? And how does this obviously influence the selection process? Because we have seen that some of the state governments in some states are now having interest in the selection process of some of these revered traditional schools. So how has their role, evolved in modern governance?
Yes, one thing about traditional institutions is that they are institutions that have been there over the years.
So we see
and
the Oba of Benin, very powerful.
Yes.
The governance.
Yes, the Oba of Benin, the Oni of Ife, the Obi of Onisha, and the Kalabari of Rivers, and other traditional rulers and institutions. They have been there over time, and they predate the current political structures and that we have, the specific we have. They have been there over time, even before the coming of the Europeans. They were there, and you recall that the Europeans, Lugard and others that came to Nigeria, they made use of the traditional rulers and traditional institutions over time. Now, in Oyo State, particularly, in 1997, they registered their declaration, the Chief Declaration, and because they registered it, they have followed it religiously over the years. Now, in 2025, the governor has decided to make an appointment not in clear conformity with the Chieftaincy Declaration on 1867. Now the question is, since it's an institution that will outlive any political governor or any political institution, so to say, will the governor choose his own stooge, his own candidate over the choice of the kingmakers? We know that these traditional institutions, there are some things they do. They make some consultations in their own way. And sometimes, according to their beliefs, the selection may have something to do with, traditional practices and all that. And since that has been the way they've been doing it over time, I believe it is proper that the selection be done the way it is being done over the years. The fact that the governor prefers one candidate over that recommended by the kingmakers does not follow. Because if you look at the powers of the governor under the 1999 Constitution, the powers of the governor is subscribed by the Constitution and other extant laws. And what is his powers? Of the states. The governor does not have powers over the traditional institutions. It is not for the governor of appointment. There are people to select. Having done that, after the bachelor has summoned for a meeting, the kingmakers have decided, selected, and confirmed. Of course, these people still have their own beliefs.
Yeah, so can
that they have, other sources of confirmation other than themselves.
Does the governor have the right to reject if some of the traditional institutions have done their vetting and have recommended?
That is exactly what I've, made the allusion to that. What governs the selection of the Alaafin of Oyo is the Jameson Declaration of 1967, and that declaration does not have any provision for the governor or anybody by whatever name called to override the proper procedure laid down in that declaration. And the declaration was registered to give it the validity that it requires, so that tomorrow nobody comes to bastardize it. The essence of getting it written down, signed, and registered, it makes it an authentic document that has clear prescriptions on the manner, the modality, the procedure for the selection of the exalted institution of the Alaafin of Oyo, who wears such wide powers. And because it is codified, it's written down, the governor doesn't have any power under that declaration to override the decision of the kingmakers.
Politics. That is to say that the governors should not even be considered in the appointment, since it's purely a traditional arrangement. It should be left within that traditional setting to do their vetting and appointment, instead of mixing traditional institution with politics.
Yes, definitely. What happens in that is this, that the entire process of selection has nothing to do with the office of the governor. Nothing at all. It is the traditional kingmakers that does that. They have their procedures, they have the ways they do it, and when finally they've come up with a candidate, they now recommend to the governor to appoint such a one. And the essence of having the governor to come into the picture is for the purposes of issuing certificate of recognition to the candidate. Because usually in some places, the governor still use certificate to whoever is a traditional ruler. And that is just for purposes of recognition by the state.
Because like you said, some of these traditional institutions predate the coming of the British and modern government in Nigeria.
Yes.
And some of these people were appointed and held office even before the coming.
Of course,
they had a process.
Before the coming of the British colonial masters, these traditional institutions were there, and they were revered, and things were going on smoothly. Now, these people, they hold tenaciously to their religious beliefs and customs. Of course, we know the story of the judge of Opobo, yes, who had to be banished because he felt that what the British colonial overlords wanted him to do was sacrilegious, was abomination. He refused to do it and he was banished. That goes to tell you the extent of the belief of these people in their traditional institutions. And at that time, of course, there were no such things like a certificate and all that, but of course, that were the levels of government at that time. And when politics came in and so on, it's okay for purposes of alignment. Let the governors and or those in power know the head of the traditional institutions, so there will be cohesion. And that has been going on over the years. And then, in Oyo State, they've taken the time to ensure that the same procedure is followed religiously over the years, and that's has been on. So it is wrong for the governor to wake up and decide he need to jettison what has been there over the years and then select someone after what he called wide consultations, not taking into account the proper group of persons, which is the kingmakers that are expected by the declaration to make the selection. The selection has nothing to do with the governor. Rather, it is the investor, the appointment, and investor of the certificate and staff office that has to do with the government.
So if I understand it properly, so from your submission,
Yeah.
I think it will even be wrong to call it appointment by the governor. From what you've submitted, we could say that, we could rightly say that the responsibility of the government is just for recognition.
Recognition.
Not
That
an
is,
appointment.
yes, even though they call it appointment in their, but the actual fact, if you to look at it critically, what there are two phases. The first phase is upon the meeting summoned by the Basharo, and after those rituals and meetings and deliberations, they will finally come up with a person duly selected by them. And that is why they are called the kingmakers, because they are the ones that make the king. It's not the governor. The governor is not a kingmaker. It's not part of them. And when they have finally made a king, they will now present to the governor for recognition.
So ordinary, I think the nomenclature of appointment is somewhat of an issue here, because if you give somebody a power to appoint, that means he has an element of power in that process. Well, if it's clearly said that what you are doing is just to recognize who we are presenting after checking if we have followed the right process.
Yes, the thing is this. The government does not have the powers to appoint. That's what I've said earlier. If you look at the constitution, they are not in the constitution that gives the governor the power to appoint any traditional ruler, so to say. And then the
recommendation and appointment by the governor.
No, the kingmakers are the ones solely responsible for the selection and then the appointment. If we are to look at it clearly, then they now recommend to the governor for recognition. There's no power. And of course, we know that whoever occupies any office, any political office, is there by virtue of a law. And the law circumscribes, the law states the powers the person that passed that position has. And in terms of the governor, the powers of the governor are clearly stated in the constitution, and it does not in this instant include the appointment of the Alaafin of Oyo, and it doesn't include embarking on wide consultations, because that is a clear violation of the declaration of 1967. And of course, the declaration was there before even the governor knows the ambition of becoming the governor of Oyo State. And we know that in Nigeria, the laws are there, and the customary laws are there. They are still to take over the duties assigned by the declaration to the kingmakers. So the governor acted, if you ask me, without necessary authority. Quo warranto, who authorized him?
All right. So, of course, if the issue persists and the court will obviously be called into question. So what's the role of the judiciary or the court, in resolving this?
Yes, that question is very clear, that over years, the courts have, upheld, sanctioned, sanctioned and declared valid the customs of the people. And in this case, I envisage a situation whereby the matter may finally end up in court. Since the kingmakers, the people that are the ones that are meant to make the king, because even from the nomenclature, the appellation, the name, kingmakers, they are the ones to make the king. And if they say that the person that the governor has declared the Alaafin of Oyo is not the one they have recommended, they are not the one that have made the person, which means the kingmakers have not made any king. And that of the governor, look at law. The Lord Denning, in the case of my friend USA, have made, a principle that has stood over the years, and that is that you cannot place something on nothing. It will collapse. Now, if the governor's appointment, while consultation, selection, and appointment is not based, predicated, anchored on any valid law or statute, it is nothing. And for that reason, if they go to court, which I expect they will go to court, they will be asking the court to interpret the 1967 declaration, whether by the provisions of the 1967 declaration of Oyo State in terms of the chieftaincy, whether the governor has the powers that he has purportedly exercised. And the court, looking at it dispassionately, will come to the conclusion that the governor doesn't have the powers under the law to do so. And that, will warrant the person that the governor have, appointed to be removed. It is better that politics is clearly isolated from traditional institutions. Let the governor allow those that are the kickmakers to be the ones to do so. If the governor, for any reason, has a preferred candidate, he can only present such candidate to the kingmakers. And if through their process of selection, the person is selected, good and fine, but it's not selected, let it be. Because there are ways they do these things, and the governor, not being a traditional ruler and not being empowered by any law to get himself, entangled in the process of king making, because kings are traditional rulers, and because they are traditions of the people, the governor ought not to dabble into that. And having dabbled into it, I tend to agree with the kingmakers that what he has done appropriately then appears to be legal, appears to be constitutional, so long as it was not done in clear compliance with the 1967 declaration.
All right. Okay, you can't build something or nothing and expect it to stand, according to Lord Denning in USA and McFoy. We'll go on a very short break, and when we return, we'll look at the second topic for today. Stay tuned. We'll be back shortly. Welcome back. If you are just joining us, you are on to your favorite program, Democracy and the Rule of Law. We're looking at the issue concerning the Oyo State appointment of the Alaafin of Oyo by the Oyo State governor. But moving away from that, we'll look at the recent appeal court judgment. We had the court to look at the issue concerning the Emirate Tozo here last year.
Yes.
You know, whereby the Emirate law, Yusuf repealing the fourth emirate that was created, which effectively deposed Emir Sanusi and installed Ado Bayero.
Yes.
You know, of course, at the taking over of office of the new governor, he repealed that law in conjunction with the State Assembly and reappointed Emir Sanusi. Of course, the matter went to court. The court upheld the decision of the governor, but obviously the appeal courts have overturned that decision, in fact saying that the decision, the entire case was reassigned and they need to start de novo, start afresh. So what do you have to say concerning this?
Yes, you say we are still happening on the same string, be isolated from politics. In Kano State, the governor, for whatever reasons he did that, we are yet to know. But he used the State of Assembly to repeal the Emirate law and depose the emir. And the deposed emir went to court. And initially there were two conflicting orders, one from the Federal High Court, which at that time we clearly stated had no jurisdiction over the matter because it had to do with traditional institution. And then the State High Court equally issued order, and then the matter proceeded, and finally judgment was given. And then the other party appealed to the Court of Appeal, and the Court of Appeal looked at the entire proceedings from the record of proceedings transmitted to the Court of Appeal, and the Court of Appeal discovered that there were instances of denial of fair hearing. And because fair hearing is a constitutional right, any breach of the principles of fair hearing has one consequence. And what is that consequence? It renders the entire proceedings a nullity, no matter how brilliantly or well conducted. That is the position of the law. And having discovered that there were breaches of fair hearing, which even made one of the lawyer to one of the parties to leave to be heard. And what does this fair hearing entail? That, of course, there are two twin pillars. That one pillar is that you must hear the parties concerned. You must hear the parties. Give them the explanation, the opportunity to explain what transpired before you come to a conclusion, one way or the other. And then we are made to understand that this, started in the Garden of Eden, where God, who is all-knowing, knew that Adam and Eve had already disobeyed him, and he still did not mete out punishment for them. He first of all asked them, have you eaten the forbidden fruit? Have you disobeyed what I told you not to do? Have you done what I told you not to do? And Adam was given the opportunity to defend himself. He told God, it was Eve, the woman you gave to me, that gave me, and I ate. God went to Eve, and Eve equally defended herself by saying that it was the serpent that deceived her, that beguiled her. Now, that principle, there are issues, you give the parties the opportunity to explain their own side of the story, to be heard. If there are presentations to make, they must be given the opportunity to make those presentations. And one is that let the party concerned be heard. Let that party be heard. And then the other one is that a person should not be a judge in his own cause. If you are concerned, you have an interest in a matter, you cannot be a party and a judge at the same time. Now, what is in focus in that of the Emirate Tozo is the denial of the right to be heard, which has been encapsulated in Section 36 of the 1999 Constitution, the right to fair hearing. That having denied one of the parties the right to be heard, that the matter had to be remitted to the State High Court, and that the Chief Judge had to assign it to another judge, and that the case should be taken afresh. Of course, the implication is that the new judge that will be assigned the matter with the parties to present their cases, present their witnesses, and everything will be done as if they are just starting. And the essence of it is that let the parties be given their right to fair hearing. It's a constitutional right. And once violated, everything done or purportedly done is null and void.
You know, of course, the principle you just explained, that's the principle of Aldi
Authorem Partem, yes,
and Nemo Judas in
Consensual. Yes.
Consensual. So obviously, what will be the implication of this? Because obviously the court didn't even look at the merit or if the decision was right or wrong. You know.
Yes, that has been the position of the law over the years. That once a party was denied his or her right to fair hearing, then whatever the court may have decided, the court may have come to the same conclusion the appellate court may have come to. It doesn't matter. The entire proceedings is a nullity. It's as if it never existed, because that right may have been done by the court. The judge might have written a brilliant judgment with plethora of cases and judgments of the appellate court. But so long as a party was not given the opportunity to present his or her case clearly, adequately, then the entire thing is a nullity. And yes.
Okay, you can finish.
And that is what I played out in this matter now. That no matter what the lower court may have come up with, no matter whatever it has done, because of that singular denial of fair hearing, everything goes to zero, and they have
could lead in the destabilization in the Kano Emirates, because obviously now that this the decision of the State High Court has been declared to be null and void. Now, does it mean that the Emir Bayero, you know, is still the Emir of Kano? What happens to the Emir that is standing on nothing since the law which brought him into place has been declared? You know, the case that purportedly, you know, settled his him ascending the throne has been decided that it is null and void.
Now, you know, there are two things there. One is that the Kano State Emirate law was repealed and a new law was put into place by the governor. Through that is the House of Assembly, you know, came up with the new Emirate law, which the governor signed into law. And with that, the former emir was deposed and a new one was installed, and the one that was deposed was not happy with it and has gone to court, and that is what is playing out presently. And there are two things that we need to look at there. Number one, the new Emirates law, which is part of what they are asking the court to set aside. If it is not set aside, then the person who is there will still remain there pending the determination of the court of the case by the new judge, because the governor signed into law the Emirates law of Kano State, which was the presumption there is that there is a law that is backing or validating the new emir that has been installed. Now, the other party has gone to court to say no, that the process was, flawed, and that that new law ought to be set aside. So as to what is going to happen is that so long as that law is still there, it has not been set aside, then it is on that law that the new emir is still, there. And at the end of the day, by the time the new judge who would handle the matter takes the matter dispassionately and comes to a decision, if the decision had the effect of nullifying the Emirates law of Kano State, then, and that what was done was not properly done, it may mean a reversion to the old order. But then, and until then, we need to wait until the court has decided. But for now, what is just that the new court that will be assigned will be very cautious to ensure that nobody is denied the right to fair hearing. And like we also said earlier, these traditional institutions are not political institutions. Some people can get to political offices through means that may be questionable, through means that may not be in tandem with due process. And that is why after elections, political elections, you see people going to court to challenge the outcome of such elections. But that is not the same with traditional institutions. They are not political offices. They have their own ways of selecting and getting someone emerged as the traditional ruler. And politicians must not, in the interest of the society, corrupt the traditional institutions. Let the traditional institutions remain what they have been over the years. And do you know that in some places, some people revere and fear some of these traditional institutions more than political office holders?
That's not water that the powers of some of these traditional institutions, because obviously the traditional institutions are the governments that are closest to the people.
Yes.
They feel the pulse of their people.
Yes.
And sometimes they also criticize government when the primary roles of the government or the welfare that the government is supposed to provide for their people do not get to them.
Yes.
They hold government, they act as a check and balances, to the government. And this is, wouldn't it be possible why the government are trying to infiltrate that institution and try to water it down?
Yes, that is exactly what is playing out for selfish reasons. So that they can do whatever they want to do without anyone, especially traditional rulers, criticizing what the government is doing. We've seen instances in the past when governors will wake up and those things are not good for these traditional institutions. They have been there and they are meant to regulate the lives of the people in accordance with the customs and the morals and traditions. That is the way we've seen it, and that must be allowed to roll parallel to. They are not to be mixed in the same pot. No. No. Let the traditional institutions remain where they are. Let the government offices and functionaries be where they are. And the governors and those in power must not try to water down the powers, the influence of these traditional rulers, or put people that are their cronies in these places.
Yeah. So because we're almost out of time, so let me just get this last question. Tradition, they say, is the people's way of life.
Yes.
Does it mean that some of the state actors or governors, they do not understand the importance of preserving the cultural heritage, of the people we serve, as their moral and spiritual, where they derive, some moral compass, and also their way of life, because those institutions help to preserve this cultural heritage that helps to, guide the people in terms of moral, in terms of religion, and in terms of spiritual well-being. Is it not important, or do they not understand the significance, of preserving these institutions?
Well, to the question, my answer is clear, that any Nigerian born in Nigeria knows or ought to know about these traditional institutions, because like Sheikh Makinde is a Nigerian, he grew up in Oyo State, and he knows